Hello, everybody. Good morning, good afternoon, and welcome to this seminar. We are sorry we had some technical issues, but now I think we are good. So, as you know, this is a seminar that are organized in a collaboration between Copenhagen Business School, the Center Imagine for Cultural and Creative Industries Research, and Center for Cultural Affairs at Indiana University. My name is Trine Bille. I'm a professor at Copenhagen Business School, and I have the honor to introduce Stina Teilmann. Stina is associate professor at Copenhagen Business School, and Stina works with copyright issues and design. And today she have agreed to talk about the consequences of AI for artist rights. So, Stina, welcome, and you can begin if you're ready.
Yes, I am. Thank you so much. So first of all, thank you for inviting me. And I've been looking forward to talking about this, which is one of my favorite topics. And then I just want to check, because we had all this I had at my end, all these technical issues. You can see the slide, right? I'm sharing the slide now. Yes, good.
Sure.
Cool, good. Okay, so AI, creativity, and copyright. So favorite topic of mine. And I'll be talking about this for next. Well, we have 45 minutes altogether, or a little less because I was messing up with the technical stuff. But I'll sort of walk you through various issues in copyright that have come along since AI became available through all sorts of apps and tools and so on. And these are things that I talk to colleagues about, mainly at sort of legal conferences, and we talk about this a lot. Sometimes these sort of issues also emerge to the public. So first of all, I want to show you what it's called the AI copyright wars. You can see a map here. It's a sort of dynamic map. You can find it on the web, and it sort of lists all the the lawsuits between basically copyright holders and AI companies. And this list is growing by the month. So you can see quite many of them in North America. And it has even a little map in the map with the US cases. So most of them there. And but in the recent few months, more and more cases have emerged more and more litigation has emerged in Europe and Asia, well, elsewhere. More to come on this. And sometimes you might hear about this in the news as well, these big cases. Anyways, this among lawyers, this is what we call the copyright input issues that have to do with the emergence of AI. And the basic issue is that the models have been trained on copyrighted materials. It's also been trained on uncopyrighted materials probably, but mostly on copyrighted materials. And no authorizations have been given for this. Then the question, the big copyright question is whether this is a actionable reproduction. It's if it is an actionable reproduction, then there's infringement. It's quite likely that that there's actionable reproduction. I mean, we'll hear that when all this litigation begins to produce results in terms of new limits to what you can do and not do in terms of training data. But the concept of reproduction is rather broad in copyright. It's direct or indirect, temporary or permanent reproduction by means and in various means and in any form, in whole or in part. So this is the WIPO definition, and also the one that most jurisdictions use in one form or other. So that means that it's quite likely that it's copyright infringement that's been going on in some of these cases. Then there's another issue that's coming up when we talk about the copyright input issues. That's the moral rights of authors. That's a continental law issue. So coming from France and Germany, and that's the right of attribution. And I think that's one particular concern of academic authors. I mean, I don't think we are very happy to have. I mean, it's not that we have to live of our royalties most of the time. We we hopefully have salaries from universities, but the right to attribution is very important when you're building a career. So you don't really want your sort of writings to be out there without your name added to it. Or even, maybe even worse, you don't actually want sort of false attribution where your name is added to something that you never wrote. That's also happened recently. Then, of course, as always in copyright, there are exceptions to the exclusive right to the copyright, and that in Europe and UK law, it's mainly known as the text and data mining exceptions, or the text and data mining purposes, where in principle it's legal to or it's lawful to actually use sort of or do the training in sort of data without asking for permission if it's for these sort of particular purposes, most of the time sort of non-commercial purposes and so on. So maybe there's an exception there. We have sort of still to find out. And then in the US, all the cases there are being fought over whether the fair use can be brought in. And of course, all the tech companies claim that it's fair use to use, all the copyrighted materials from like the New York Times or from Reddit or from Getty or wherever they found training data. They say that it's a form of transformative use, which is actually in support of the fair use defense. Or they can also say that it doesn't cause market disruption. For say, if you train on New York Times, and if you can say that it was not to compete with the newspaper, but for developing technology, then there's no market disruption, and then that also counts in favor of the fair use defense. Right. So I was just going to mention a recent case that has been going on here in the UK, in Europe, and that was Getty. They were suing Stability AI, and they had a sort of copyright. They had a sort of copyright count and a trademark count to this case, and you can see some of the sort of images that were used as evidence in the case. And here, actually, what Getty was doing is that they were demonstrating that with relatively simple prompts, like the prompt Obama news photo, they would get images that were sort of very close to the images that came from Getty's database of images. So that was the evidence they brought before the court, the High Court in the UK, and they sort of in the end they simply couldn't. They had to give up on all the copyright counts in this case, but they did win on trademark. Sort of a little funny, but they won on the trademark questions, because as you can see, the little watermarks saying sort of Getty images, they kept on appearing, even though I don't think any user would want. They never asked for a sort of Getty Images watermark to be on these images, but they sort of came along, and that's obviously because these models had been trained on Getty Images sort of photos. Anyway, so this they had to give up for sort of various reasons. They had to give up on the copyright questions, but they won on the trademark questions. Getty Images did, but there are still more cases coming out. So we'll hear more about this. Then there was another thing that sort of emerged, probably that many have sort of who are not sort of in general interested in copyright, perhaps. But this was sort of the Ghiblification at the launch of the Chat GPT-4 Omni in March 25, and that was when everyone was starting to sort of Ghiblify, their photo albums or whatever, all sorts of things. So this was obviously because there had been sort of training taking place on sort of Ghibli or sort of the Ghibli studio art. But the question was also on what we call the sort of copyright output issues. So no longer about training data, but actually about the output that comes out of the models. And the thing about all these sort of Ghiblified images here is that they were not, none of them were really sort of infringing, because what they were copying was more or less the style, very recognizable style of Studio Ghibli, but it was only the style, and style is not something that you can have copyright in. So some people even began arguing that there should be a sort of copyright in styles. I'm not so sure about that, but anyways, so it was at least someone was trying here to to suggest some approach going back to this. Anyway, so the thing about these models is that, or AI, is that services that can be used to generate content that sort of very much looks like sort of creative expressions of people, and it also may very much look like something that is already out there. Sometimes it's not just a sort of style imitation. Sometimes there's what we call memorizations. So there are one-to-one copies of like there's been sort of one-to-one copies of various Walt Disney figures, for example, and that they are definitely sort of in the usual way copyright infringement, but also sometimes there are sort of short, sort of extracts of images or works that that might also constitute a copyright infringement, because if it in some way is copying something that's original, so in the EU that's the whatever is sort of the author or the creator's own intellectual creation, sort of if there's a partial copy of that, then there can be copyright infringement. The next question is, of course, is who's liable, and there might be sort of primary and secondary liability in this. I'm sort of still curious to see who's going to be found to be liable. I mean, we as users, could we end up being sort of liable if, like we say in the Getty sort of Obama case, sort of if I sort of make a prompt and suddenly it sort of comes up with something, I might not know that it's an already existing image, that what I've made is a one-to-one copy. I never asked for that. I just asked for a news photo of something, and I expected it to be synthetic sort of content, but then it's actually just a one-to-one copy. Am I liable then? Probably. We'll see. But also the platforms and the service providers and the model developers and so on. We're still to see about many of these questions. And again, there are sort of exceptions and defenses. So like before, sort of fair use can be a defense. Fair dealings in UK. So there's also in Europe, there's the pastiche exceptions and parody exceptions. So you can do this in some cases. So those were the copyright output issues. Then there's a third issue, which is sort of copyright in automated content. So there are a few cases of that in the US. So for example, this Saria of the Dawn. So that was registered with the US Copyright Office. So in US, you sort of register your copyrights, unlike in Europe, we don't. It's not really a requirement, but in the US, there's tradition for doing that. And this was, Saria of the Dawn was first registered as synthetic content, sort of automated. And then the registration was simply rejected because it was automated. Then another one came up. That was sort of the cheese one up there, Kent Kersey. Sort of I have the little image of it. And that was at first it was registered as sort of automated content, and then it was rejected. But then he came back and said, "Oh, actually, there was sort of human sort of choices in there in terms of arrangement and other things." And then it was actually the registration came through. So other things that people have said about sort of whether that can be copyright and automated content is that for now there's no real sort of 100% automated content. It's everything is always semi-automated. So people are discussing about creative prompts, for example, so that all the creativity goes into making really good prompts. The bigger question is sort of the rationale for copyright. I mean, why do we have copyright anyways? And sort of my view is that copyright is actually existing to I mean, I don't think copyright is a natural right. I think the copyright is there for society to incentivize creativity, whether it in however form it is. But I'm also thinking that automated creativity probably doesn't need to be incentivized. It'll happen anyway. So I think I don't quite see the point. But we can talk about this. Then another problem, sort of systemic question, is that whether human contribution is even auditable in synthetic content. So how can we even? I mean, creators might be in good faith and say, yeah, I did this, but maybe you can't. Maybe you can't always remember exactly what you did or how you did it. So auditing how much is human, how much is machine, can be really hard. Then finally, again, there's this role of the moral rights, and I think that's, this protection of attribution and against false attribution. That are sort of at least sort of big concerns of mine when we talk about automated content. So I wanted as a final thing to mention deep fake. So that's a particular type of synthetic media, of course. So that's you could say the the digital replicas that can exist of people. And there's a big debate because they play a role in deep fakes. I mean, it's been part of revenge porn. It's also been part of fake news discussions and so on. So there's a big debate on how to actually regulate deep fakes. And Denmark has moved ahead and simply just done it. And there's a Danish bill right now for where the proposal is that there should be a protection against deep fakes under copyright law. So we're supposed to actually have this enter into force in the spring of 26, where Danish copyright law will come to introduce a general protection for all persons against these realistically or these digital replicas, and also a protection against the artistic performances of performing artists. So it's interesting where this is going. I'm not totally sure what. I'm not totally persuaded that copyright is the right legal instrument against deep fakes, because copyright is, that's about monetizing on your creative work, and it's a sort of right that can be transferred to the other parties. But this deep fakes, in a way, that's just what you want to prevent. It's not something you want to monetize on, or maybe it is. So I'm wondering, why do we have it in Denmark? Maybe it is that we're just trying to create a way of monetizing your avatars or something. So again, but this is just speculation. So I think this was more or less what I wanted to say, in this quick tour through AI, creativity, and copyright. And thank you for listening. If you have anything you want to discuss, I'm totally happy to. Thank you.
Stina, you're muted. Sorry, I was muted. Sorry. Thank you so much, Stina. That was a very interesting talk. I can see a lot of reactions here. There is a question in the chat, and I can also see that people are writing this was very informative. There's a question from Vicky. Maybe Vicky, I think it works better if you want to post the question yourself. I can also read it loud, but it might give better dynamics. Would you like to post your questions?
Sure. So I work with young artists, and we have a lot of interest in this because a lot of them are experimenting with AI or using AI already quite a bit. And we also teach them about the rights to publicity that almost anyone has to their imagery. And there's laws, state laws in the United States that protect your image of your face, of your likeness. So I wonder if that would be a protection against the deep fakes, at least a partial protection.
Absolutely. And that's what, and people, and that was always thought of as a sort of way to commercialize your face. So that definitely it is. It can, but again, it's the sort of the logic of publicity rights is that you should be, it should be possible to transfer those rights or sell licenses to sort of the usage of your face. And there's always if someone does that without your authorization, there's always the enforcement question, which is really hard because you'll have to sort of find who's been doing it and so on and so on. All the difficulties we have already with the online sort of violations of that type. But definitely, yeah, good point.
You are very welcome to raise your hand if you have a comment or a question. No, yeah, Doc, go ahead.
Sure. So I wonder what you think about a farther future where we have more. I mean, yeah, so 5-10 years down the line, and a lot of the AI or more agentic AI that are going out and creating a lot more of this content with arguably no or extremely distant human involvement in content. Where do you see the more long-term regime going for copyright?
I mean, I think I think that a lot is going to change when we get the more sort of agentic web, and I think maybe we do want some sort of protection of our avatars because probably we are somehow. I mean, maybe in I don't know 15 years from now, this meeting would be conducted with our avatars. So we want some sort of control over that. The question is always whether it's. I mean, we need sort of well, it's always funny copyright has been such a flexible sort of branch of law over time. I mean, it really has changed since it first came in. So never say never about copyright. So it might be that copyright suddenly begins to become really useful in this. So yeah, so I would say totally possible. And now that we have deep fakes under Danish law, but I mean, who's to say what's it's probably some.
Thank you, Stina. Michael Rostan, you have a question?
Yeah, thank you very much for this. This has been really informative. I've been trying to look ahead to see what is the sort of end game of the development of large language models and authors' rights and so on. And, it's the law trying to catch up after the horses have bolted, more or less. Do you see in the future if the most practical solution might be some kind of compulsory license so that works can be used, but authors are owed a certain amount and that can be negotiated at a fairly broad national or even international level? I wondered if that's ultimately where we're going.
I think so. And I know that in all the collecting societies across, I mean, Europe and the US as well, they are beginning to set up this sort of, and there's also sort of the extended collective licenses that we have in Europe. And but definitely, I can't see, I simply cannot see individuals or even sort of just small organizations having any say in this. It's So yes, mandatory licenses and mandatory remunerations. It's going to have to happen. So a bit like, I mean, we can compare with all the Google Books cases. That was an out-of-court settlement, which was perhaps good for some of the people involved, but not so good for legal certainty. So every time there's an out-of-court settlement, it creates more uncertainty and maybe more power to those who are powerful already. So I think it's good to actually have sort of statutory changes for this.
Thank you. I can see there's a comment here by Sharon. It relates to Michael's comments. I don't know if you want to elaborate on that. I think you're, yeah.
Thank you.
Perfect.
Thank you. I don't have really much to add. I just was thinking maybe the same thing as Michael was thinking as he was writing it too. There's got to be some collective way to protect artist rights. As in Canada, as I said, we have a public lending right, which compensates authors for the use of their works by public libraries. And it's administered centrally. I think probably that doing this for AI generated content might be considerably more complicated, but I'd be open to hearing ideas from people as to how could national governments do this, or is it something that's best left to the private sector or to international bodies? I'm just asking the question because I'm already starting to think about this myself. Thank you.
Thank you.
So one if I respond,
Yeah.
I think one thing I've sort of argued for is that there should be we should have something called data set law, because I think what's really, we always talk about, I mean, why would we have mandatory licenses, for example? That's because we think that it would hinder innovation if suddenly artists would not allow their work to be trained on. So we see some sort of value in actually having available data, and we know that sort of the big data creates a lot of value. So we want this sort of innovation, but then my big worry is that only if we just allow things to happen in their own way with out-of-court settlements and so on, then we'll see things like the deal that happened between a group of artists or authors, maybe it was authors, and Anthropic. So Anthropic, one of the big, the sort of model developers. And that was an out-of-court settlement, and they paid like over $1 billion, which was good for those authors, of course, but it's not so good for any little developer of models if they can't get access to quality data. So in a way, we should have a sort of, we should have an open market for developers of different LLM models or whatever, and they should have access to quality data. But we can't have a situation where only those who can pay $1 billion for the quality data, they can actually get into the game of innovation. So the data set law would sort of regulate this access to quality data that is needed for actually have a sort of broad market for innovation.
Yes, I think there's also this question about how much can we do at the national level compared to the international level. Yeah, I don't know if you have a comment on that, because I think that's also on our minds in most countries, what we can do about this.
That's true.
Mm.
Yeah, the thing with the Getty, the case I mentioned in the UK with the Getty images, one reason why Getty had to give up on the copyright count was that everything had happened in the US. So if it happens on servers in the US, then it's outside of jurisdiction, and then that's it. So in Europe, we would sort of, there would be nothing we could do, because it was sort of, I mean, you can do sort of jurisdiction shopping and just find a place where it's legal to do whatever you want to do as a tech company.
Yeah, that's
So
also
we need that.
Yeah, we do.
Yeah, so we definitely need something in that goes sort of is above single jurisdictions.
Sure.
But thank you so much for the comments.
Can anybody hear me?
Yes.
Yes.
Okay, because I'm having a hard time figuring out how to raise my hand. I'd like to hear some discussion and maybe think a little bit about how the whole computer thing developed, and how you used to just buy a program for whatever you wanted to do and you owned that program, and now all the companies are just selling you something for a time, and they are innovating, but they're doing it with something you've already bought. I mean, you bought something and it's not closed, it's not yours, but now you have to sort of subscribe, and then constantly it's getting changed. It seems to me that puts us at a bit of an advantage if we had something where we purchased a certain program that contained a certain amount of AI, and it was basically ours then because we purchased that particular design for our use. Then that what we created on there would indeed belong to us, not to the company that created the project and we paid for it. It seems to me that's a different kind of approach, an approach that we started out with. You used to just go buy a Microsoft program or some kind of program publisher, put something on your machine that you would use, and nobody came along and changed it. And if you wanted a better version, you went out and bought it. So this situation where everything, I agree, you've got to have innovation, but I don't know whether we all have to have innovation at the same time. Whether the innovation can stay outside of what is our creative business. That's what I would like to hear some discussion on. Thank you.
Mm-hmm.
Thank
Sure.
you.
And I think, thank you. And I think, I mean, you're right. I mean, that's what's happening. I mean, we're buying licenses, so we're not really buying anything. And we're just paying for licenses with software these days, and everything is in the cloud and so on. So nothing is really ours online. And that was sort of, we gave up sort of the real sort of ownership when we sort of went digital. Even books that we sort of e-books that we buy. I mean, there has been cases where we know that these books sort of e-books you had actually bought, they were removed from users for various reasons. So nothing we sort of think we own digitally is really ours. It doesn't come with the same sort of possession that we have in the physical world. But I agree that many of the I mean, it's maybe good for Microsoft, but not so good for us that we sort of are trapped in this sort of licensing, sort of eternal licensing.
Maybe if there were a company out there that would basically produce something in that way that would be an ownership for us, could they maybe capture the creative market in a way, if they indeed would do that. I mean, we'd have to, we'd have to pay something, but then we pay something for everything that we get now, really, when you get right down to it. And if we basically lose control over our own creativity, we are really paying a very high price for what we're getting from the companies.
Yes. And I think, I mean, now when we're using sort of apps or whatever creative AI of different types, I mean, there's still, if we, you should just try and read some of the terms of use I know I always say this, so Trine is maybe tired of hearing me, and Alicia might be tired of hearing me say this, but if you start to read the terms of use, then you'll find that everything you write, everything you design in some AI tools, you don't own it. I mean, it's not yours. If you use Midjourney, then Midjourney has the right to do whatever they want with something that you have designed. So even though you made 100 prompts sort of and created something that was quite special, then it's not yours.
And it's like you can't even keep AI out. They put it in whether you ask for it or not. You don't even have a choice as to whether it's in your email or whether it's reading your email, which seems to me a blatant disregard for privacy to have a machine come in and read my email. But that's what is happening if you're using, email these days, because all the companies want to put AI on your stuff, whether you want it or not.
Yeah.
Thank you. I think, Sharon, do you have a comment on your question?
I just want to continue to pursue this international licensing or regulation idea. I noticed that Michael again suggested maybe a new sort of Berne Convention.
Yes.
And I do agree that there are some problems there. But I wanted to ask Stina if there is any work going on within bodies such as UNESCO or the OECD to address this kind of issue of creative rights within AI. I do know that the OECD was looking at a general digital tax that has not yet been negotiated, but I'm not aware at this point of anything else, and I was wondering if you were.
I'm afraid I don't know. I mean, I should hope so. And I imagine that they do, but I don't know.
Doug, I can see you also have a comment in the chat or question.
Yeah. This was going away from the international a little bit, but and maybe it's going back to my agent bit, thinking about agentic AI. Let's say we charged people, someone wants to train their LLM on the New York Times corpus. And so they have to pay the New York Times the rights to train. And then I'm a user of, Anthropic that's paid New York Times to train on New York Times. As a user, then Anthropic's tool starts spitting out a lot of content. And now I've got a lot of this content that's been informed by New York Times content, but it's new content. Can I then just go and train a model based on this? Not the primitive, not the original topic, but the second stage stuff. And how do we transfer down rights for things that are multiple generations removed from the original creators? What does that look like in the big scheme? This is all new to me, so it's all fascinating. And I also want to, before I let you answer, echo the early comments in the chat here that this is incredibly informative, and I'm loving it. So thank you.
Thank you so much. And I think your question, at least part of your question was what happens when we train on synthetic media. Is that right? The thing is, it all goes wrong. so then the models degenerate. So then we get really bad, sort of really bad content coming out. So that's why there's been this race, at least with the current technologies, where this race for getting the quality data. But I also, in the more dystopian moments, imagine a sort of world where sort of models just train on sort of automated content, and it gets worse and worse. And so.
Yeah, thank you.
Yes, Stina, do you have time for one more question, or should we say thank you? I don't know. You have to leave a little bit earlier.
Yes, but I can do one more question. Sure.
Okay.
Thank you.
Okay. I think there's a question here from Sui. Zoe, do you have a question? Yeah.
Yes, yeah, similar to Doug. Well, first of all, Stina, thank you. I'm also very interested in this subject matter and I really enjoyed the presentation. I'm thinking about it similarly to Doug in terms of like the creative class and just how we will define the value that comes out of AI and large language learning models. I'm curious just to hear your thoughts about like how that value definition will go, like come about in terms of if the value is in like thought generation and we're using thought generating partners, like what is the balance in that? And you mentioned who is liable. I'm just curious if you could expound on that.
Yes, thank you. I mean, I'm thinking about this a lot, so it's a really good question. What's going to happen? I mean, when you look at the reports coming out from, I mean, some of the big consultancy houses, then I mean that's the class that may be a class of workers that's really at risk here. And I think, I mean, the risk is not necessarily that automation can do what people could do, but it's maybe sometimes actually the risk that we think that, or employers might think that AIs can do what humans can do, and then they sort of give up paying humans to do it. I think that's actually as big a problem as I mean, any challenge with whether sort of AIs can actually do the jobs of humans. It's sort of the belief that they can do it, and I think that it can be. I think it's very important for humans to define what we want to do with AI. So I think so. I don't know if you know Cory Doctorow. So he says that we should think of ourselves as sort of machines and humans. Think of them as centaurs. So we want the human to be the head. We don't want the human to be the body, and then the AI to be the head. So think of yourself as the head, and then sort of have AI help you, and not the other way around. And that's a sort of nice image to work with. Of course, it's hard to put it into practice, but it's a good way to begin to think about it as a creative class. Thank you.
Thank you, Stina. I think this was a great seminar, and I think it was really, really informative. And thank you for all the good questions and comments. I think we have to end now, but it was great that you all participated. And again, thank you so much, Stina, for this great seminar. Thank you.
Thank you so much. Bye.
Bye.